All right, good evening, everyone. Just going to wait till we've got a couple of people tuning in here. Welcome to Thursday evening edition of Employment Law Q&A. Happy to have you all here. My name is Alex Lucifero. I am an employment lawyer and partner with Samfiru Tumarkin LLP. Here for another edition of Employment Law Q&A, here to answer all of your employment law questions. This is your chance to speak with an employment lawyer live right here, right now. Ask your questions in the chat. I will do my best to answer every single question. We're on for half an hour tonight from 7 to 7:30, so please ask away. Don't be shy. Don't be bashful. We're here to help try and resolve your workplace questions, whatever they are, whether you're dealing with a difficult boss, whether you've maybe been laid off from your employment or your changes are happening to your job and you want to know what your rights are. Maybe you've been let go and you've been offered a severance package. You have no idea whether the severance offer is fair or not. Ask away. This is your opportunity. I don't know much about anything else, but I know about employment law. It's the bread and butter of my work. It's what we do all day, every day here at Samfiru Tumarkin. I see some questions coming in, which are excellent. I'm going to get right on those. Carrie, let's get it started. So Carrie asks, my husband was injured on the job 16 years ago and has a physical disability as a result. He was hired back 6 years ago as a health and safety rep. Laid off when COVID hit. He works for a moving company, and the boss admitted he won't be bringing him back because he's disabled and can't do as much as others. What are his rights? Well, Carrie, if your husband has been told that there's no way that he is being brought back to work, that is a termination. Whether you have an actual termination letter and it's official and it's in writing doesn't really matter. If your husband has been advised that he's never coming back to work again, I mean, how isn't that a termination? That is very clearly out and out a termination. And as a result of that, your husband is owed severance. His severance is going to be based on his age, his position, and his years of service. And if he's, a 16-plus year employee, his severance entitlements are going to be significant. Now, over and above that, Carrie, if your husband has been told that he's being let go basically because of his disabilities, that's a huge problem. That may very well be discrimination. You cannot let an employee go because they need accommodation in the workplace or because they can't necessarily do things exactly like a fully abled employee can do. So that's potentially an issue as well. Not only would your husband potentially be owed severance, he may also be owed additional compensation as well for effectively what's discrimination on the basis of disability. Again, an employer cannot decide to let an employee go because they need physical accommodations in the workplace. So hopefully that answers your question, Carrie. Certainly it sounds like your husband needs legal advice. I'd encourage you to give us a call or send us a quick email. Let me get out that contact info right now for all of you viewing. The email address is help@employmentlawyer.ca. That's help@employmentlawyer.ca. You can email us at any time of day. We will get back to you as quickly as we possibly can, and we will absolutely get back to you. Again, whether your problem is big or small, someone will get back to you and point you in the right direction. If you want to do some general research, if you want to get to know more about a particular topic, whether that's COVID layoffs, like Carrie was just mentioning, or whether it's harassment in the workplace, again, whatever the issue is, find our website, employmentlawyer.ca. Employmentlawyer.ca. We have a ton of resources, and you can, search articles. You can look up, recent blog posts. You can also look up older articles and whatnot. Really, any topic under the sun when it comes to employment law, when it comes to your workplace, we will have some basic information on that. Listen, it doesn't displace actual legal advice from a lawyer. So maybe you want to do some quick reading, get a sense of your situation, and then reach out to us at help@employmentlawyer.ca. to actually get in touch with an employment lawyer and have that conversation. You need to reach out. You need practical legal advice if you're having difficulties at work. You don't want to make a decision on your own without getting legal advice. You may very well make the wrong decision and end up doing yourselves damage in the long term. You need guidance, you need help, and the way to get that help is to just reach out to us, contact us. We are more than happy to help in any way we can. Okay, Dan asks, can airlines mandate the vaccine for their staff? Good question, Dan. The short answer, in my opinion, is no. COVID vaccines are going to be mandatory, I would say, in very, very few, if any, industries, in any workplaces. I think really the only one or two areas I could see COVID vaccines being mandatory, effectively being required by employees and mandated by employers, is in either the healthcare industry. There have been previous cases with respect to the flu vaccine in Canada that have been made mandatory in some hospitals. I think there's one previous case on that subject, and you can see COVID also falling under that rubric of being kind of so important, so crucial to employee health and to patient health and care, that becomes mandatory in a hospital setting. I can also potentially see long-term care facilities and long-term care homes as potentially one day being a work environment in which COVID becomes mandatory. Other than that, Dan, other than, again, maybe hospitals and maybe long-term care homes, I do not see employers being able to enforce employees getting the COVID vaccine in any other industry, whether it's airlines or customer service, retail, whatever it may be. Even food processing and agriculture. I really don't see that happening. It is a very significant and heavy burden on an individual, on an employee, to actually mandate that person get vaccinated. The courts will not take that kind of obligation lightly, rather that is, and certainly they'll value the individual's liberty and really their kind of self decision making in order to protect that individual's rights over what an employer may ideally want or require, and what might be best for the workplace. So I don't see it happening, Dan, but it's a very good question. Certainly, it's a topic that's been in the news a lot. It's been in the news, over the past few months, and something that moving forward, I think we'll see in some very, very limited industries. Again, healthcare mainly, but not in the majority of cases. Wanted to touch on, now that we have a break in the questions, I actually wanted to touch on an issue that came across my desk actually just earlier today, and that's to do with severance. A lot of times on our Facebook lives and on our kind of live YouTube events, we talk about harassment in the workplace. We've been talking a lot about COVID-19 and temporary layoffs and changes to the work in COVID, but it's important to remember that a lot of the people that reach out to us are reaching out to us with respect to questions about severance. They've been let go from their job, and either they've been offered some sort of severance package, or what we also see a lot is a lot of employers letting employees go and not offering them severance whatsoever, either because they claim that the employee did something terribly wrong, or related to COVID, they are claiming what's called frustration of contract. Now, frustration of contract is a very specific legal term, and it basically means that through some sheer kind of act of God, an employer simply can't continue an employee's employment. And those are very, very rare cases. We don't see them often at all. And even something like COVID wouldn't be considered a frustration of contract situation. And I spoke to a lady actually earlier today who actually received the severance offer. So she was wanting to know whether it was reasonable or not. And this lady was actually residing in Kingston, Ontario. So I'm in Ottawa. We obviously speak to people across Ontario and in Alberta and Vancouver as well. This particular lady lived in Kingston, Ontario, which is relatively small city, relatively small workforce, small economy, and she was let go from her job after 18 or nearly 18 years of service, being only in her mid 40s. So this is someone who really had been with the same employer since she was quite young, since she was in her early 20s. And since coming out of school, she had been with this one same company for, again, almost 18 years, and she had worked her way up to a supervisor position. Now, unfortunately, because of the economy, because of COVID and the fact that this employer's business had taken a turn for the worse, she was let go after 18 years of solid service, good employee, no issues with her performance, no issues with her conduct. She was let go after 18 years of service, and she was offered a very minimal severance package. She was basically offered her minimum entitlements under the Employment Standards Act. Now, so for those of you watching that don't know, an employee's minimum entitlements are what is provided in a piece of legislation, at least in Ontario, although similar legislation exists in other provinces, a piece of legislation called the Employment Standards Act. Now, the Employment Standards Act provides for kind of bare bone minimum entitlements for employees. So in the Employment Standards Act, you'll find rules about minimum wage, minimum amount of vacation, you'll find rules about overtime pay, about hours of work, et cetera, et cetera, et cetera, all kind of the minimum rules that form basically the minimum obligations that an employer has to an employee. An employer cannot provide an employee with less than what's provided for in the Employment Standards Act. And the Employment Standards Act has some rules about termination and severance pay as well. And so this employee, again, she was 44 years of age, let's say 18 years of service with the company, her minimum entitlements under the Employment Standards Act were 26 weeks of pay. 26 weeks is 6 months, effectively. It's half a year's pay. And that's what this company offered this lady. They offered her her minimum entitlements under the Employment Standards Act. And they said, here's what we owe you. This is what the Employment Standards Act says. So we've done everything we have to do. We've met our legal obligations. We don't owe you anything more. And again, this lady reached out to me and said, well, is that correct? Is it the case that all they have to provide me with are these minimum entitlements? And well, I had some shocking news for her, because she doesn't know the way the law works. If you guys tuning in today, watch our show or listen to our radio program, the Employment Law Show, if you've done any kind of research at all about severance, you'll know that this is the case. This lady didn't know. She thought that these minimums were basically what a company had to do. And I had news for you. What I told her is that, well, no, those entitlements under the Employment Standards Act are an employee's minimum entitlements. They're the bare bones, again, of what she had to receive. It doesn't correspond to an employee's full severance entitlements or their actual severance entitlements, which are calculated on the basis of an employee's age, their position within the company. In this case, this lady was a supervisor, and the amount of time an employee's been with the same company. Those are what we call your full severance entitlements, what are also referred to as your common law entitlements. And almost always, an employee's full severance entitlements are way more than what the Employment Standards Act says. So let's take this lady as an example. And here's exactly why I wanted to talk about this situation on our live event tonight. Again, this lady was with the company for 18 years. It's a lot of time, obviously. Good for her for sticking with the same company for such a period of time. And obviously, she was doing something right for the company to want her around for that period of time. So 18 years of service, in her mid-40s, in a supervisor position. Company offered her 6 months. Her full entitlements, her common law entitlements that she is owed, is actually about a month per year of service. So it would be something in the range of about 18 months. Again, as someone in their mid-40s with 18 years of service in a supervisor position, you're looking at something about in the year and a half range. Now, let's compare that to what she was offered. She was offered 26 weeks of pay. That's half a year. She was literally been offered a year's pay less than what she is actually owed. I mean, it's incredible. It's literally 3 times what she was offered. And this was, of course, news to this lady. She had no idea the severance worked. And so I had to go through the analysis I just went through with her and actually did some research on my own and gave her some examples of cases in which employees of her age, position, and years of service received severance packages in the range of 18 months. And so now I'm going to be assisting this lady get the severance that she's owed, make sure that she's paid the proper amount of severance. And it's a lesson for all our viewers out there that you cannot take an employer's word for it. Just because your employer tells you that their severance offer meets the legal requirements, just because they tell you that an offer might be fair from their point of view, you cannot take an employer's word for it. You have to do your own due diligence. You have to speak with an employment lawyer. And a lot of times, I would say almost always really, an employer's severance offer is going to be far less than what the employee is actually owed. The employer is making a severance offer hoping that it will get a good deal. They are looking at this as a business transaction. And of course, they want to be able to, as much as possible, minimize their liability, minimize what they have to pay, because again, that represents a good deal. It represents good value for a company. You have to be doing the exact same thing from the employee's point of view. When you are faced with the severance offer, you have to try and maximize the value from your end. And that's not money hungry. That's not crass. That's not improper. You are doing, as an employee, the exact same thing that the employer is doing, which is looking for maximum value in what's really just the breakdown of a relationship and the parting of ways. Dan, another question here. Is it better to quit instead of getting fired so that you don't have a bad record of employment? No, it's not, Dan, simply because, terminations are quite common. Most terminations are what we call without cause, meaning it's not for the fault of the employee. It's not because the employee's done anything wrong. And so you don't have to be bashful or shy or, feel as though a termination will ultimately be a stain on your record. It's really not. A record of employment is something that's confidential. And so it's not as if employers will be able to see whether an employee's been terminated or resigned or terminated for misconduct or performance or anything like that. And of course, then when you quit, well, you don't get any kind of severance payment whatsoever. You'll get your pay until your last day of work. You might get whatever vacation pay you've accrued up until that point in time, and that's it. There's really nothing else left. So a lot of times we'll speak to employees who are struggling in their workplace, who feel like they have no choice but to resign. And sometimes resignations will allow you to seek severance as well. I'll touch on that in a sec. But most of the time, unless you're dealing with harassment in the workplace, unless you're dealing with kind of a really, really poisoned work environment, you want to put yourself in a situation where the employer makes the decision to end your employment, because that is a termination. And in a case like that, you're going to be owed severance as an employee. And as we just touched on with my example, and it's a real life example, I'm actually going to be assisting, the 18-year employee I was just discussing. Your severance entitlements are going to be significant as an employee who's been let go. I should probably also add that a lot of times, even though an employee is terminated, we're able to negotiate a letter of reference from the previous employer. And so that should do away with any concerns you have about, a bad record of employment or any concerns you have about being terminated. Again, there's nothing wrong with being terminated from your employment. It's obviously a difficult time in anyone's life, practically speaking. But again, it's not a stain on your employment record. It's not going to haunt you in your future career. So, if you're in a situation, Dan, where you feel like you're being forced to resign, well, number one, you should certainly be obtaining legal advice. You want to talk about why you're feeling that way and what your legal rights are and what your protections are in the circumstances. And a lot of times, it's better to just kind of let the employer make the decision to let you go rather than resign. Now, there is an exception to this situation, Dan, and I alluded to it previously. And a lot of times this will happen where either an employee is dealing with harassment in the workplace, or you're dealing with poisoned work environment, or even in situations where your terms of employment are changing in a significant way. in one of those situations, and again, before you make any kind of decision, you want to make sure you speak with an employment lawyer so that you know what your rights are. I don't want any employees out there resigning on the spot and then contacting us saying they resigned and are looking for a severance package. But there may be instances in which, again, in response to harassment in the workplace, in response to a change to the terms of your employment, an employee could resign and still obtain their severance entitlements. It's what we call a constructive dismissal. And a constructive dismissal is basically a breach of contract. It's when an employer does something so terribly wrong, right? Either in the form of, again, harassment in the workplace, or in the form of really significantly changing the terms of your employment. When they make such a significant change to the terms of your employment that you're just kind of, you're shocked by it and you don't know what to do, you can potentially resign, right? Not accept those new terms of employment and still obtain a severance package. I'll give you a quick example because I'd like to answer Layla's question here. And let's talk about temporary layoffs. A temporary layoff, despite COVID, despite what you've heard in the news, despite what employers may have been telling you, a temporary layoff is not necessarily something that's allowed. An employee has to accept that. They have to accept temporary layoffs as a term of their employment. And so if an employer tries to force a temporary layoff on an employee and the employee doesn't want to agree to it, you can treat the imposition of that temporary layoff as a breach of contract, as what we call a constructive dismissal. And you'd basically be resigning your employment in response to that and seeking severance package and seeking termination and severance pay. Now, again, before any of you out there think that they should be resigning their employment and then, speaking to a lawyer after the fact to seek severance, don't do it, guys. Before you resign, or even before you accept, any new terms of employment, you want to make sure you get advice. You want to make sure you speak with an employment lawyer. And the way in which you do that is you contact us at help@employmentlawyer.ca. Send us a brief summary, 3 or 4 or 5 lines, maybe a paragraph or so, describing your situation, and somebody will contact you right away to try and help you out and, again, point you in the right direction. And our website as well, if you want to look up any info, if you want to look up, the lawyers at our firm, which offices we have. We have offices in Vancouver, Calgary, Toronto, Ottawa. Employmentlawyer.ca is where you can find this. You can find a ton of information there. You can also find all of our contact info there. All right. Layla, we've got about 8 minutes left here, guys, so get in your questions. Don't be shy. I'm more than happy to answer any questions you have. Again, you've got an employment lawyer here ready and waiting, ready to tackle any questions you have, so don't be shy, guys. We don't have much time left. Layla asks, is the 3-day COVID sick paid leave available to union members who have already used up all of their sick days? Wow, great question, Layla. So my understanding is that these paid sick days apply to all employees across Ontario. Now, in a situation where you are unionized and you are under a collective agreement, there might be a process there by which the union has to amend the collective agreement to kind of reflect the new changes in the law. That shouldn't be a quick or that shouldn't be rather a slow or complicated process, because again, this is stuff that should apply to all employees across the province immediately. It's kind of your bare minimum entitlements as an employee. So the short answer, Layla, is yes, you should be able to access these. Keep this in mind, Layla. And I actually did an interview on CTV earlier today on exactly this topic. The provincial, and I'm talking Ontario here, guys, the provincial 3-day paid sick leave that Ontario is provided is a maximum, or provides a maximum of $200 a day. It is good for things like if you know you're going to be off of work for a couple of days, for 2 or 3 days. It might also be good in situations where you're going to get vaccinated. You have an appointment for your vaccine and you have to take maybe a day off, or maybe you're not feeling well because of the side effects of the vaccine, and you have to take a couple of days off. That's maybe where the provincial 3-day paid sick leave can come into play. But if you've contracted COVID, or if you have to quarantine and you know you're going to have to be out of work for, let's say, something like 2 weeks, the 3-day Ontario paid sick leave is probably not the right option. You will probably want to exercise the federal benefits that are available to you, which is the Canada Response Sickness benefit. It provides potentially for less money. It's only $500 per week, but it lasts longer. The minimum amount of times is at least 2 weeks. So you can take 2 weeks off of work and receive $500 a week, and it can also last much longer than 2 weeks if you're still medically unable to work as a result of COVID. So if it's a short-term leave, Leila, you probably want to access the provincial plan, which is the 3-day plan. If it's going to be a longer leave because you might have to quarantine for 2 weeks, or you're actually ill and just can't go to work for an extended period of time, and let's say you don't have short-term disability benefits or any other, or as you mentioned, you've already used up all your sick days, the federal program might actually be the better one. But whether you're unionized or not, you should be able to access those benefits. You might have to go through your union to do so, but it definitely should be something that all employees in the province should have access to. Kate asks, I think it's sad that there's nothing that can help people with terrible unions, do nothing about harassment and failure to accommodate. You make a good point, Kate, as much as I really hate to say it, but unions are certainly positive about a number of things. Unions are good to obviously secure your employment, so you have much more secure employment when you're dealing with a unionized workplace. It's much tougher to let go of unionized employees for whatever reason. They also generally pay better, usually have better hours, and there's kind of perks that come along with being a unionized employees. Of course, you have union dues to pay, but it is difficult to enforce other rights through your union, Kate. And I have to agree with you. When you're dealing with harassment in the workplace, when you're dealing with disability issues or medical leaves, and even when you're dealing with severance, I have to say that unions make life much more difficult for those employees. When you're a unionized employee, your severance entitlements are going to be minimal. You're going to be bound by what's in the collective agreement, and you're not going to be owed a penny more. And a lot of times the collective agreement will only have severance entitlements that are employees' minimum entitlements, which is what we were talking about previously. As you mentioned, Kate, I've seen plenty of situations before when we're talking about medical leaves and accommodation in the workplace for people with disabilities. Unions, and again, I hope that this is the exception, but unfortunately I've seen it lots. Unions will do kind of the bare minimum to help an employee who's having issues with either accommodations in the workplace, or even if they're having issues with their disability insurer, when they're having issues with short-term or long-term disability benefits. A lot of times the union will have very, very little to do with that employee. Again, they'll do the kind of the bare bones minimum. So I hate to say it, Kate, but you're probably not wrong. I hope that unions kind of eventually catch up with the rest of the employment law world when it comes to protecting employees in this situation, because they protect employees in lots of other cases, lots of other kinds of situations, but they fall short in some pretty important areas as well. IC Solutions asks, does your firm handle international cases? Well, unfortunately not, IC Solutions. We practice across Canada, but we don't practice anywhere else. If you're potentially looking for a referral for someone in, let's say, the United States or even in England, perhaps, we might be able to assist, but unfortunately we don't handle international matters, at least just yet. That might be on the horizon for the firm. Maybe we'll expand internationally one day, but certainly appreciate the question. I think that will do it for tonight, guys. I hope that I've answered all of your questions. I hope I've given you some food for thought when it comes to, if you're an employee, preserving, protecting, and understanding your rights in the workplace. Employees have far more rights than they actually usually know that they do. Employment laws in Ontario and in Canada more generally are actually quite favorable. They're quite helpful to employees, but of course the law can't help you if you don't know what the law is and if you don't know how to implement, again, your rights and protections. And certainly if you're an employer watching this, you need advice, and you have employees in the workplace, you need advice from start to finish, whether it's hiring an employee and offering them an employment contract, or it's treating an employee during their employment, or it's terminating an employment, as an employment lawyer, it should be standard practice. Just like you need financial advice, you need advice for an employment lawyer when you're operating a business. If you guys want to contact us off air, maybe you're too shy or too bashful to ask a question online, help@employmentlawyer.ca is the email address to reach us. We get back to every single person that emails us, so do not be shy. Employmentlawyer.ca is the website as well. Like I said, a ton of resources, a ton of information, and all of our contact info that you can find and reach us with any of your employment law concerns. I will see you next time for our next edition of Thursday night's Employment Law Q&A. Until then, it's been a pleasure. It's been an honor answering your questions. Wish you all the best for the rest of the week. Have yourselves a great weekend, and we will talk soon. See you next time.